Um, Good afternoon, everyone. Thanks very much for joining the session this afternoon or this evening. It's pretty dark outside. So I really appreciate your time. My name is Nigel Everett. I'm the General Manager here at Sterling, and we're joined today with the team from Equity Trustees with the new Laurie and Danielle, and Trish is kindly sitting behind the scenes driving the presentation. So today's session is the second of these and the first of our webinar series that we'll be running this year on the very important topic of estate planning. The session on Tuesday was great, and I think a lot of really good information that we were able to impart, and I have no doubt you'll get a lot of value out of the session today. Just a couple of things as we go through from the perspective of how you ask questions. We've got everyone's camera and microphone turned off. If you'd like to ask a question on the way through, then up the top you'll see a button that says Q&A. All you need to do is click on that. It will bring up a box and you can ask a question in there, and we'll get to that question as we go through the presentation. At the end of the presentation, we will open it up, and if somebody would like to ask a question, we'll explain how to do that then, and we can just unmute and away we go. So that's out of the way. Without further ado, I'll hand over to Anu. So thanks, Anu, and enjoy the session, everybody.
Hi, everyone. Thank you for joining us today for our estate planning webinar. My name is Anu Menon, and I am a Senior Solicitor and Business Development Manager at Equity Trustees. Now, I've worked in estate planning for about a decade in financial services, trustee companies, and private practice, and now at Equity Trustees in our Melbourne-based office. I'm joined by my two Sydney-based senior estate planning solicitors, Laurie Savitz and Danielle Radomiski. Laurie was admitted to practice in 2012 in New South Wales. She's worked both in private practice and trustee companies since this time. She joined Equity Trustees last year, and she prides herself on developing a tailored, robust estate plan for her clients. Danielle has extensive experience across wills and estates, having exclusively practiced in this area since 1998. She has worked in banks, trustee companies, and private practice, but she's also managed her own firms just before joining our team earlier this year. She's passionate about taking the time to understand each family's objectives and formulate effective succession planning strategies. Trish, if I could get you to go back to the last slide, please. Just before, sorry, earlier. Okay. Yeah. So just a bit about our company before we get started today. Equity Trustees is now Australia's largest and leading professional trustee company. We specialise in helping families plan for their future. Our main areas are in estate planning, wills, powers of attorney, which you'll learn much more about today. We also administer estates professionally within our estate management team and can manage trusts as trustee, whether they're set up during your lifetime or after death. We do operate nationally with offices across mainland Australia. So Laurie and Danielle are our Sydney-based lawyers. I practice in Melbourne. But we do have a team of about 13 lawyers who can assist across mainland Australia. Equity is a proud partner of Sterling Planners. We work together to bring holistic and specialised estate planning services to clients, taking into account their personal affairs, tax considerations, asset protection needs to provide a tailored estate plan for you guys, the clients. So today on our agenda, if we can go to that slide, please, Trish. So what we'll be covering today are some of the estate planning basics, tips for a comprehensive estate plan, the documents you need, what's within and outside of your estate, what you need to consider when appointing an executor, implications for non-residents when they're appointed as the executor under your will, testamentary trust wills, what are they, what are the benefits, when are they relevant, and we'll include, I guess, of particular relevance for you guys is considerations where you have assets overseas in the UK or beneficiaries overseas. We'll then look more generally at powers of attorney, as they are state-based documents, but we'll provide you with a general overview. And then we'll put this into practical application with a useful case study before we open up the floor for some question time. Now, a quick disclaimer that today's presentation is intended as a source of information only. We can provide specific tailored advice to your circumstances when we meet with you for an estate planning meeting. I'll hand you over to Laurie.
Thank you, Anu. So, yep, tips for a comprehensive estate plan. So Trish, if you can just jump to the next slide, please. Thank you. So it's important to note that estate planning, it's not just planning for death, it's also planning in life. And essentially, it's not just a will. But what is a will? So a will comes into effect on death, and it's critical that a will is drafted and executed correctly in accordance with the relevant legislation. For example, it must be signed and dated in the presence of 2 adult independent witnesses. I'm going to touch on some key points that you should consider when putting in place your will. Firstly, you should consider who will be the executor of your will, and Anu will explain the executor role later in the presentation. You need to consider if you want to include any funeral wishes, for example, cremation, burial, or organ donation. Do you want to give any specific gifts, for example, charitable bequests, or gift your engagement ring to a particular child? If you have minor children, it's critical to appoint a guardian. What if you and your spouse weren't living? Who has the role to look after the children until they're 18 and make their day-to-day decisions? It's also important to decide how you want to leave your residuary estate. For example, to your spouse first, and then equally to your children, and at what age you would be happy for your children to receive their inheritance. And then there's consideration that needs to be given to that catastrophe clause. What if your spouse doesn't survive you and your children and your grandchildren, something happens to you all at the same time? Who do you want to inherit from your estate? Is it wider family members or charities, or even perhaps creating a charitable foundation through your will? And lastly, the Trustee Act, it's a very old piece of legislation. And as we do not know what powers the executor and trustee requires, it's best to expand on the standard trustee powers. And that's what our wills do. So what happens if you don't have a will? Essentially, then, the laws of intestacy decide how your assets are divided. And in New South Wales, the Succession Act sets out the intestacy rules, and it's a hierarchy as to who is entitled to your estate. And this may not be who you want to inherit your assets. So it's essential that you have a valid will in place because it ensures that your assets are going to the beneficiaries who you want to benefit. And it also makes it a lot easier for your loved ones. It's more of a straightforward probate application as opposed to a letters of administration, which can be costly and timely and just a lot for your loved ones. So that's the will in essence, but what is an estate plan? So whilst a will deals with your physical assets, an estate plan is a holistic approach and considers your total wealth, including superannuation, business interests, family trusts, and who will control your care and finances should you lose capacity. Now more than ever, individual circumstances are complex. For example, ownership of assets, protection of assets, their tax implications, blended families are on the rise. And then you have superannuation to consider, and perhaps you even have a family trust. And are there even vulnerable beneficiaries, you're concerned about, for example, children with disabilities or a child with a substance abuse issue or a child who has mental health concerns? So as estate planning lawyers, we encourage a collaborative approach with your accountants and financial advisors so that you have a robust estate plan and that it enables the transfer of wealth in a tax-effective manner and identifies risks and challenges to the estate, for example, potential family provision claims. So it's really important that you have an estate plan in place that appoints the right individuals to roles such as executor, attorney, and guardian. So now I'm going to talk about estate versus non-estate assets. So what assets actually form part of your estate? Now, the will can only deal with assets that are owned in your sole name when you die. Assets which are owned jointly with another person passes directly to the surviving person via survivorship. So those assets aren't going to form part of your estate of the first who dies. And that's why it's sitting there separately on the right-hand side of the slide. Now, this differs from your share of assets, which are held as tenants in common. For example, you might own a property and have 60% share, and the other individual who you own it with has a 40% share of the property. So taking this example, when you die, that 60% share does form part of your estate and will be distributed in accordance with your will. So therefore, it's important that you know how your assets are held. Are they held jointly with another person or as tenants in common with another person? And that's really important to consider, when you're considering your estate planning. Now, a common misconception is that superannuation automatically forms part of your estate. This is not the case, and you should put in place a death benefit nomination that directs the trustee of the super fund where to pay your member balance on your death. And this will also include any life insurance within your superannuation. Now, these death benefit nominations, they can be binding or non-binding. We usually recommend that they are binding because therefore you're binding the trustee of the super fund that they have to pay it in accordance with the nomination. Non-binding, it's more as a wish, essentially. Now, sometimes death benefit nominations can lapse every 3 years, and therefore it's important that if they do, you keep them up to date. And as I said before, if it's a non-binding or if you don't have a binding death benefit nomination, it's really up to the trustee of the super fund where the benefits are paid to, and it might not be where you want those benefits to go. So again, it's about taking that decision-making ability and ensuring that your assets, such as your superannuation, go where you want them to go. Now, also superannuation benefits can only be paid to a spouse or a child, or for example, to your legal personal representative, and that's just another word for your estate. But if you do nominate your legal personal representative, then it comes through your estate and gets distributed in accordance with your will. So just like superannuation, any standalone life insurance policies also require a separate nomination. So again, you can nominate a beneficiary or your legal personal representative. So some other assets to consider may be a family trust. Now, family trusts are another topic in themselves, but it's important to note that any assets in the trust will not form part of your estate. All your estate can deal with is passing control of that trust. So usually there's a corporate trustee of the trust. And for example, you might hold shares in that trustee company. So therefore, it's important that you consider when you die, who are you gifting those shares to via your will? Because the shareholders can appoint directors of that company and they ultimately have control. There's also another important role to consider in trusts, and that's the appointor role. Now, the appointor is a passive but powerful role. It may never be required, and that's why we say it's passive. But if it is required, it's powerful because it can hire and fire the trustee. And again, great consideration needs to be given as to who the successor of the appointor is if you hold that appointor role. Now, the successor of the appointor can be dealt with via your will, but that's only going to deal with the circumstance when you die. So we also, for example, recommend having a deed poll in place to cover that situation if you lost capacity. So then that role can be filled. So now we're going to move on to the next slide. And we're going to look at some estate planning documents. So in front of you, you'll see a list of documents which make up an estate plan. And later in the presentation, these will be touched upon, but I'm just going to quickly speak on the supporting documents. So a statutory declaration can be important For example, when it comes to your domicile, and Danielle will touch on this later, but especially if you've got UK assets or you've resided in the UK before, domicile becomes very important. And therefore, to take away, any discrepancy as to where you were domiciled, having a statutory declaration in place can really assist your executors when you pass away. Another important document is known as the Memorandum of Wishes. So, this is not a legally binding document, but I say it's morally binding, and it really gives direction and shows what your wishes are. For example, it might be to the guardians of your minor children, some values that you would really want to let the guardians know on how you would want your children to be brought up. Or it might be to the executor of your will or the trustees of any trusts. And even though these memorandum of wishes aren't legally binding, as I said, they are really there to show what your intentions are, and they can be really valid. So I'm not going to elaborate on any of the other documents due to time restraints, but as part of the estate plan, it really illustrates when you look at the list there that it's critical that all the supporting documents are reviewed. As I said before, the estate plan is really a holistic approach. So Anu is now going to discuss the executor role.
Thanks, Laurie. Another important consideration when drafting your will is the appointment of executor. Now, an executor is appointed in a will to manage the estate after the will maker's death and to distribute the estate assets in accordance with their wishes. It is a highly administrative task. It involves a lot of running around, a lot of project management, and a lot of patience. Some of the duties at a high level include locating the last will, obtaining the death certificate, arranging the funeral, locating and identifying the beneficiaries of the will, quantifying the assets and the liabilities, which may mean obtaining valuations, and in that process would mean writing to each organisation that the deceased was involved with, applying to the court for probate, which is the court seal of approval to then start or give permission to the executor to start distributing the assets in accordance with the will. Then the executor proceeds to collect the assets so that they can be distributed to the beneficiaries, which often mean liaising with various bodies to ensure an effective transfer can occur, such as share registries, land titles offices, and so forth. Typically, this process can take about 12 months, but it can take longer, particularly where there are additional complexities, for example, complex assets, businesses, properties which are more difficult to sell, for example, high net worth, overseas assets, but also where there's challenges to an estate. It can really delay the process. What we often see as a professional executor is that facts and figures are often the easy part of the job. It's often the emotional and personal side of an estate that can be much more difficult and cumbersome. Administering an estate can often create and renew family conflicts. We often see arguments over personal effects that might have sentimental value to a particular beneficiary. We often see disputes over a beneficiary wanting to retain a certain asset as part of their share of the estate. Unfortunately, death and money can bring out the worst in people. And quite often families will appoint their children, family members or close friends to this role, not really knowing what could come out of the woodwork or what the dirty laundry that could be aired as part of that process. Executors do need to be unanimous in their decision making. So you can see how this can lead to dispute and frustrate the administration process, particularly where you see, for example, quite commonly, mum and dad appointing 3 children to the role. And maybe they don't see eye to eye on how assets are to be dealt with, or a third party spouse gets in the air and doesn't agree with how something's dealt with. Some other considerations would be the age of the executor. Will they be around to take this role on? Do they have the time to take on these duties? They might have a family of their own, work commitments, and as I said, it's quite a time-consuming process? Do they have the financial acumen to make sound investment decisions for the estate? And Danielle will touch on some of the tax implications, particularly for non-resident estates. Now, that's some of the decision-making that the executor would need to make as part of winding up the estate and making a decision around what assets should be dealt with how, and taking into account some of those tax implications. Often people are appointed to the role of executor. They do take on ongoing roles as trustee under the will. Quite commonly, as Laurie mentioned, they might be trustee for minor beneficiaries. And that could be an ongoing role for quite the duration if it's a trust that's managed for a beneficiary until they're 25, for example. And it involves managing that trust, investing the trust assets or the funds for that time period, and being the gatekeeper of those funds to make distributions for relevant education expenses and so forth. Importantly, did they sign up to mediate all the family arguments that we didn't expect to arise? If we go on to the next slide, what if the person appointed as executor resides overseas? For a lot of people that have moved to Australia, close family might not be within the country to take on the role of executor. Can you appoint someone who is overseas or in the UK to this role? Technically you can, but there are a number of reasons why it might not be practical to appoint a foreign executor to the role in your will. Do they need to travel to take on this role? Whilst many tasks can be undertaken remotely, there are some that are better off to be attended to physically. For example, obviously the funeral arrangements, the sale of the properties under the estate will need to be arranged, and most often the properties will need to be cleaned out and all the personal effects sold and dealt with or distributed in accordance with the will. Unfortunately, we can't really rely on the postal system, and documents do get lost in transit, and that can result in delays as well. Being in different time zones can also make menial tasks take a lot longer than expected. Now, from a tax perspective, it can be quite expensive having a foreign executor in the will. There can be a few tax consequences. If your executor is considered a non-resident of Australia for tax purposes, then this means that the estate will be subject to the same rules and the same tax rates as a foreign resident. For example, the estate may not be able to access the income tax-free threshold. They may not be able to obtain franking credit refunds. They may not be able to obtain the 50% CGT discount on the sale of assets of the estate. And they also might attract the higher penalty tax rates where there's income derived whilst the estate is being administered. Something important to note is that it doesn't matter that the deceased was an Australian tax resident. Their estate will not be a resident trust estate for tax purposes if the executor is not an Australian resident. So there can be some real merit in appointing a professional trustee company such as Equity Trustees to this role, as you can keep the central management and control of the estate within Australia. Your estate would be managed by experts who have the resources and the staff to administer your estate. The estate would be assigned an estate manager who is sort of like the customer service point of contact for all the beneficiaries. And they also project manage the process, liaise with all the beneficiaries, the specialists in tax and property, but they're there to do the hard part, navigating the family dynamics and mediating any disputes as an independent. Over to you, Danielle, and the next slide.
Before, sorry, Andrew, before we shift over to Danielle, there was just a question, so we might as well cover it on this section, and that was from Bronwyn, which was, does the estate have access to all those tax benefits or the beneficiaries under the estate? She didn't realise that the estate was a person as such.
Sorry, could you repeat that question?
Yeah, you can look at it on the Q&A on the top.
Q&A. Just loading. Does the estate have access to those tax benefits or the beneficiaries under the estate? The estate is considered like an entity. It essentially is a trust, and you will need to do a tax return for the trust or for the estate at the end of the administration process. And so there are some tax considerations when an estate's being administered, which could potentially be lost where there is a foreign resident that's appointed as the executor. And the points on the slide are some of those examples as to what taxes would come into play where a non-resident is the executor. I hope that answers your question, Bronwyn.
Yes, I think it does. Thank you.
Okay. Thanks, Anu. So at this point, let's focus on how you gift your estate to your beneficiaries. It is usual for clients to first opt for outright gifts to their chosen beneficiaries, say a gift to your spouse with a gift over to children once they attain a certain age chosen by the will maker. An alternative to an outright gift is establishing one or more testamentary trusts so that the inheritance is paid to a trust for the benefit of a primary beneficiary and other beneficiaries determined, usually by class, by you, the will maker. Often the testamentary trust is discretionary, which means the trustee has the discretion to pay as much or as little of the income and/or trust capital as the trustee determines. The trust is administered by the trustee, which can be also the primary beneficiary. These trusts are often referred to as bloodline trusts. They can operate for up to 80 years, though the trustee can wind them up earlier at the trustee's discretion. These trusts allow for intergenerational gifting. So while the will maker at the time of making the will is benefiting, for example, his or her spouse and children, the trust can operate longer so that it benefits grandchildren and great-grandchildren who are not yet born at the time of the will or even at the death of the will maker. There are many different types of testamentary trusts, and how a trust is structured really depends on the needs and the circumstances of the beneficiary and the will maker's wishes. For example, if a beneficiary has a special need, a disability or a vulnerability, an all needs protective trust would be more appropriate for them. There's two key benefits to testamentary trusts. Firstly, they afford asset protection for beneficiaries. Because the beneficiaries do not personally own the assets of the trust, like they do with an outright gift, the assets are held in the trust and administered at the discretion of the trustee. So if the trust is structured correctly, trust assets can be protected from beneficiaries' creditors or family law proceedings of their departing spouses. Secondly, testamentary trusts offer tax minimisation via income splitting. So while a trust will pay the highest rate of tax, each year the trustee can pay a beneficiary $18,200 tax-free each year. So if a trust earns $100,000 of income and the trustee distributes the tax-free amount to the spouse and, say, 3 children in a year, then the trust is only paying tax on the remaining $27,200. That income can still be distributed, just not tax-free. So that introduces you to testamentary trusts and how they can enhance your estate plan. Now, let's turn to overseas assets, will makers, and beneficiaries. Thanks, Trish. Nowadays, it's common for clients to own assets in countries outside of Australia, often because a client was born, raised, and lived in that country, or lived and worked there for a period of time at some point. I understand that some of the attendees here at this evening's webinar hold assets in the UK, such as a UK pension and an associated bank account, at least. And while the focus of this portion of the presentation is on the UK, the information can be applied generally to assets held in other countries. At Equity Trustees, when we work on your estate plan, we provide you with advice regarding your will so far as it deals with your assets in Australia. It is important that you get tax and legal advice about the assets you own overseas from advisors in that jurisdiction and how those assets will pass under the terms of the will that we prepare for you. We always advocate for you obtaining tax and legal advice in those jurisdictions and encourage a collaborative approach to work with your accountant, financial advisor, and other advisors, whether they be in Australia or abroad. Regarding UK assets, you may already be aware that the UK has inheritance tax, which applies to people who are domiciled in the UK and is determined on the value of your estate at the date of death and can be up to 40% over a certain threshold, which varies case to case. Depending on the nature of your domicile, the inheritance tax may catch your worldwide assets, a scary thought for many. Because laws and taxes vary so much between countries, we recommend the two-will strategy. And that's the first point on the slide. That is making a will in each jurisdiction that you hold assets. Sometimes making a will in each jurisdiction is necessary because different countries have different requirements for a valid will. But even if it's not necessary for that reason, we still think it's better to have two wills because it minimises the chance of administrative difficulties occurring after your death if the original will is held in one country, say Australia, while there are other assets in another country that need to be administered and distributed. But when putting in the two-will strategy, consider their application. Make sure that each will is clear on what assets it captures and what laws of which country are to apply to the administration of those assets. Further, as most wills will include a general revocation clause of former wills that you've made or past wills that you've made, it's important that the two wills don't conflict with each other and that one will doesn't inadvertently revoke the other will. We recommend that the solicitors writing the wills in each jurisdiction work together to ensure that the wills work and that they meet your objectives. So let's consider the issue of domicile of the will maker. In the UK, inheritance tax applies to those with UK domicile. So your domicile position is key. And it's important that you work with your accountants to understand the definition of domicile in the UK. I do have a little bit of good news about that, but I'll say that a little later on. You should consider not only your domicile circumstances and asset holding at the date you put in place your estate planning, but also what it might be at the date of your death. And we appreciate that that's not always possible to know, but to consider that it could change over the course of time. If on your death you have domicile in the UK, you may be required to pay UK inheritance tax and possibly on your worldwide estate. However, if you only have Australian domicile, you're likely to only be required to pay UK inheritance tax on your UK estate. Some clients say to me, the value of my UK holdings is very minimal, so I won't bother making a will in the UK. In this situation, where there is only an Australian will and probate of that will has been obtained, it will need to be resealed in the UK in order to deal with your UK holdings. This can bring to light your Australian assets and bring them into the realm of the UK inheritance taxes. That's especially why you should make two wills, or if you are just making just one will, and that's here in Australia, restrict it to Australian assets only. Questions around a person's domicile are not always easily answered, especially when increasingly clients travel abroad regularly, having family and friends who live overseas, and sometimes staying for longer periods, longer than a usual holiday, especially with flexibility of remote working arrangements and the like. If you're from the UK and you have relocated to live in Australia, it can be important to capture your domicile intentions or actual domicile situation if it's no longer evolving in a statutory declaration or a memorandum of wishes, so that if questions are raised by authorities on your death, the statutory declaration can support your executor in answering those probes. The statement can then be updated by you if your situation changes. Some examples of information that you would include in that statutory declaration would be how long you've lived in Australia, whether you have Australian citizenship, if you've been educated here or how long you've been educated here, if you work here, how long you've worked here, if you own a home, have bank accounts or other assets in Australia, whether you vote in Australia, if you lodge tax returns here, if you have superannuation here, and if you consider Australia as your home. And the breaking news update on domicile is that from the 6th of April 2025, the current rules for non-UK domiciled individuals will end. The concept of domicile as a relevant connecting factor in the tax system will be replaced by a system based on tax residence, which I don't have a lot more information on, but I think that might be a little more in line with what we have in Australia, whether you're a resident or non-resident. So also considering, still on the same slide, sorry, Trish, in considering how you're going to gift your estate, do be clear in your intentions about who your beneficiaries are and if they're non-Australian residents. This is the third last bullet point on this slide. If they are non-Australian residents and you leave them certain categories of assets, such as equities or shares, then that gift will trigger capital gains tax event K3. Let's call it K3. K3 was brought in to prevent assets with an embedded capital gain escaping the Australian taxation system or being taxed at a reduced rate, heaven forbid, if they are later disposed of by a concessionally taxed entity or person. It's generally regarded that the estate is responsible for paying the deceased's expenses, including tax liabilities such as these. Unless your will says otherwise, this K3 liability will be settled by estate funds from your residuary estate. And that means that potentially your resident beneficiaries will pay toward the K3 liability that's been incurred by the non-resident. You should consider who pays this liability. Is it deducted from the non-resident's gift, or are you happy for your estate to pay it? And on the last point, know about foreign person provisions. This point is specific to New South Wales. In 2020, a tax law came in where a trustee of a discretionary trust, for example, the testamentary discretionary trust that I spoke about earlier, so a testamentary trust holding New South Wales residential property is deemed a foreign person unless the trust deed expressly excludes foreign persons as beneficiaries and provides that this exclusion is irrevocable. If foreign persons are not irrevocably excluded and there's any residential property in the discretionary trust, then there's a surcharge land tax on any residential property in that trust payable by the trust. Some clients are comfortable with this, but if you're not, then tailoring structuring of the trust is needed. Having now spoken about wills and arrangements for when you're no longer living, what if you lose capacity and the ability to make your own health decisions and manage your own financial affairs? We recommend that you put in place lifetime documents. These are state-based documents in Australia, which vary state to state. They're often referred to as power of attorney, enduring power of attorney, and states that have separate documents for health appointments, they're often called enduring guardianship. What these documents allow you to do is appoint one or more people to act as your guardian and make health decisions for you for the time that you can't make your own health decisions, or appoint one or more people to act as your attorney and manage your financial affairs at the time you specify, or if you lose capacity. You choose what order these people are appointed to act, and if more than one at one time, do they act jointly or severally, or otherwise. You can provide when their power to act starts, although for health matters, it's only ever if you can't make the decision yourself. You can provide directions on how they're to use your powers and authorise your attorney in some states to confer financial benefits on people named by you in the document. For example, your spouse, dependent children, or other dependents such as parents or others. Any benefit conferred on others is only from your surplus funds. They are funds in excess of those needed to sustain you for your lifetime. Allowing for conferring of benefits allows for families to continue the usual flow of funds that has been in place, notwithstanding the incapacity of one spouse or the person. Many clients will opt to appoint their spouse or other family members to be their financial attorneys. We recommend that clients consider appointing equity trustees, even as a last option. So if all of the individuals that you appoint cannot act, then you've got a trusted company that can step in to manage your affairs in your best interest. Also, having a power of attorney in place will assist Sterling planners, your financial advisors, and other advisors to continue to advise you via your attorney, notwithstanding your incapacity. If you do have assets overseas, we recommend you make a power of attorney in that jurisdiction also. So if you lose the ability to manage those assets, the person you select can step in to manage them for you. Further, if you reside overseas for extended periods or regularly, you might also consider making an enduring guardian appointment in that jurisdiction in case you lose the ability to make your own health decisions while you're over there. If you don't have an appointed financial attorney or health guardian and you lose capacity, then those nearest to you will likely have to apply to the relevant tribunal in your state to have a financial manager or guardian appointed to you. While the tribunal is careful to appoint the most appropriate person or people to you, they may not be the choice that you would have made had you made the selection. Separate to this are advanced health directives, which also vary state to state. These directives are a way for you to state what healthcare treatments you would like to have or refuse should you be in a position that you're unable to communicate the decision about your care and treatment. This document would be used by your health guardians made under a power of attorney or enduring guardianship. It's a document that you usually complete with your doctor or healthcare professional, though some states require a legal certificate also be completed. Once you've put in place these documents together with your will and other supporting documents, you will have a comprehensive estate plan, which you should read over each year that you sign or authorise your tax return. And on that point, I'll hand back over to Laurie to speak about when you should review your estate plan.
Thank you, Danielle. So that's a nice segue into, is your estate plan current? Now, estate planning, as Danielle said, it's not a set and forget. So just as important as preparing an estate plan is ensuring it's kept up to date. So if any of you have a will in place, think about whether your life circumstances have changed since making that will. For example, have you had children since then? Or maybe your children are now adults. Maybe you've purchased another property. You need to adjust your estate plan and ensure it remains valid and in accordance with your instructions. So as a general rule, as Danielle said, keep reviewing it every year, or if you can't review it every year, I say every 3 to 5 years or earlier if you have major circumstances changes, for example, changes financially or relationship-wise. And you can read through that checklist in your own time. But as we've said, reviewing your estate plan is critical. You know, for example, a lot of people don't know that the act of marriage actually revokes a will. So it's just really important that you keep your estate plan up to date. And if you take away anything from today's presentation, it's a good reminder just to have a review of your estate planning documents. Okay, so we'll move to the next slide and we're going to have a look at a case study now. So the next slide, so you'll see this is about Maureen, and Maureen made a will and it leaves her entire estate equally to her 2 children, Catherine and Marcus. Now, at the time of her death, Maureen's estate was about $3 million and she also had a property in the UK. So at the time of Maureen's death, her daughter Catherine has 3 children who are all minors, and Catherine has returned to full-time employment and she lives in Australia. Now, opposite to this, Maureen's son Marcus, he lives in the UK, and perhaps we'll say that he doesn't have any children. So what should Maureen have done in relation to her will? So there's a few things that Maureen could have considered. So the first is perhaps creating the option for Catherine to have a testamentary discretionary trust will through Maureen's will. Now, if a testamentary trust was an option for Catherine, she could then split the income earned from her inheritance amongst her 3 minor children to save tax. And as Danielle said previously, you can income stream approximately $18,200 to each minor prior to paying any tax. So we see this in practice a lot, and a lot of grandparents who set up testamentary trusts through their will, it's used to pay for grandchildren's, private school fees. Now, conversely, a testamentary trust may not be beneficial for Marcus because he doesn't reside in Australia. And as I said, he doesn't have children. So this is why it's important that the will is drafted in a bespoke manner, and it's also important to have flexibility. So for example, when we are drafting testamentary trust wills, we like to keep them very flexible, and they can even be optional. So it might be that Catherine takes up the option to have her testamentary trust and Marcus doesn't. And it can also be optional in relation to what assets they put into their trust. So, it can be certain assets they put in or a percentage of their inheritance into the trust. So flexibility is key. Now, in relation to the appointment of executor, as Anu mentioned previously in the presentation, it might not be practical for a non-Australian resident to be an executor. So for Marcus, given his location, because of the time difference, it might just be too difficult for him to be an executor. Now, in this example, even though Catherine is living, if she wasn't living, perhaps this is when a professional trustee company could be appointed as an executor because, as it's previously been said, by having an Australian resident as an executor, you are not having those tax implications or impracticality issues. And another example, as Anu touched on, is that perhaps Catherine and Marcus don't see eye to eye, and that executor role, they have to make unanimous decisions, and we see it a lot in practice where it causes a lot of interesting family dynamics, and siblings just can't agree, and you get to that stalemate situation. So sometimes even having a private trustee company like Equities Trustee as that last resort, can be really important. Now, in relation to the UK property, Maureen should have prepared a will in the UK. So we're going back to that 2-will strategy. She should have had a will dealing with her UK assets prepared by a lawyer in the UK, and a will dealing with her Australian assets. And as Danielle said before, it's imperative that the wills don't revoke each other. So it's really about the estate planning lawyers working together. And again, if there was an issue or a debate about Maureen's domicile, she could have put in place a statutory declaration just to assist her executors if there was any doubt on her death as to her domicile. And that's it for me.
Okay, so thank you everyone for joining us today. I hope you enjoyed and found the presentation useful. Now, if you just move to the next slide, we do have a special offer for all our Sterling clients. This is our pricing for estate planning. It is covered by packages, which usually involves and includes a will as well as those lifetime documents. As Danielle stated, they do differ state by state, but it will encompass all the powers of attorney that you require for financial, medical, and lifestyle decisions. Your standard will package includes exactly that, a standard will with outright bequests, whereas a complex will package involves some sort of some type of trust in the will. Or further complex drafting. So the package prices are stated there. And having worked in private practice, all 3 of us would probably attest to the fact that that's probably about half to a third of what you'd pay in private practice for private practice solicitors who are doing the same work. I will add that there are additional costs where there are structures, so where there's a self-managed super fund, family trusts, businesses, companies, but your solicitor will be able to provide you with a fixed fee quote at the end of the initial meeting. So if you go over to the next slide, you can see, just one more slide over, please. Trish?
I am.
Yeah, perfect. That's just our contact details. And if you do want to access the offer, please get in contact with your advisor. Any questions?
Great. No, thank you. Look, on the Q&A, there are a couple of extra questions on there. If you just like to have a quick look.
Yep. Okay. So we've answered Bronwyn's question. I think, Caroline, your question's sort of similar. If the executor is not a beneficiary in the will estate, do the tax considerations on slide 12 still apply? Yes. It's not about the beneficiary or whether the executor is a beneficiary. It's about the residency of the executor and whether that renders the trust to be a foreign or a non-resident trust. In which case these tax implications would occur. Matt Landon has a question. Could children who travel overseas for a gap year or two under a visa be considered foreign residents in an estate? Who wants to take that one?
I say ask your accountant. The accountant is absolutely the best person, because they're doing the tax return, to know, because there's different levels that you can get caught as a foreign person for different purposes. Informally, unofficially, I would say probably not, but again, the accountant would be able to confirm that.
Hey.
Cool.
And I see there's a question there that's probably directed more to for me. If I think it's Penny has asked, if the lifetime documents differ state to state, which they do, and you move interstate, are the existing ones no longer valid? So in most cases, there are mutual recognition laws between the states. So the document, so your New South Wales document, if you move, say, to Victoria, will still capture your assets down there, or if it's enduring guardianship, still can be recognised there. I would just double check the situation. Like if you're moving, I would have your solicitor. If we're your solicitor, we could double check that for you to see if you should update them. So it doesn't invalidate them. It's just whether that state will recognise them.
I'll just add to that, Danielle, that there are mutual recognition laws. It's ridiculous in the first place that there's so many different laws in Australia to govern powers of attorney. But unfortunately, when it comes to the time that you need to use the documents, they aren't always as easily administered or as easily used. So best practice, even though they are meant to be recognised, is to have a new power of attorney put in place, particularly if you know it's a permanent move. It's much easier for your attorney to be able to manage your assets or deal with the doctors if it's in the form that they're comfortable with.
Exactly.
Cool. Okay, well, just before we open it up, I just wanted to make a quick comment. I actually personally went through my estate plan with equity trustees not that long ago. And, one of the things that I thought particularly around the executor side, my wife and I thought long and hard about what we should do. I've got 4 children. So in the end, what we decided was the 2 older ones, who are probably a bit more sensible, would be the executors, and my brother-in-law as a backup in case they didn't want to do it. And then thirdly, equity trustees as the corporate. So there's always a backup in case, because they can always choose not to do it. An executor can choose at the time that they haven't got the time to do that. And you need somebody behind the scenes that can manage it for you. So that's a really important thing. And after we did it, we felt so good that, we actually got that done. So that was great. So finally, there's just one question there from Stephen, and that was, what are the best options for storage of the will on the estate documents?
Good question.
You want me to answer that one? So at Equity Trustees, we have a safe custody facility. So if you do your estate planning with us, we can hold all your estate planning documents in safe custody, and there's no additional charge for doing so. And the benefit of that is that documents can go missing all the time, and especially with the will, it's vital that when it goes in for probate, you have the original will. Otherwise, there's all difficulties, and it's actually, not a straightforward probate. So that's, something that we offer as well. That's very beneficial.
Thank you. Now we're pretty much spot on time, a couple of minutes to go. If anybody does have a question they'd like to ask using their voice, not their fingers, if you wanted to hit the raise hand button on the top of the screen, and then from there I can unmute you and you can more than welcome to ask a question. And if not, then we'll close up. There you go, Stephen. You can unmute if you want to ask a question. Just have to unmute at the top, and where it says mic.
No worries. Thank you. Can you hear me all right?
Yep, all good.
Yeah, just wondering what the options might be or what you might recommend about estranged relationships. So estranged from an adult son, in my particular case. And how what I've been reading and what I've heard is that it's often a good idea to leave something in your estate for that person in the hope that it'd make that there's less likelihood of being any what's the word? Sorry,
challenge. Any challenge?
Challenge, yeah. Any challenge to the estate planning. Just wondering what your thoughts are on that.
Anu?
Do you want me
to take it? Sure.
Yeah.
So what state are you based in? New South Wales?
In New South Wales, yes.
Yeah, okay. So in New South Wales, there's legislation under the Succession Act, and it's known as a family provision claim if what's known as an eligible person was to make a challenge on your estate. So first of all, to get over that threshold to challenge the estate, they need to be an eligible person. But in your situation, a child is. So they make that threshold. It's hard to give specific advice because it depends on various factors. For example, what's the size of the estate? So if you're talking about a $50 million estate, then yes, giving something is going to try and mitigate that claim. But unfortunately, there's nothing that prohibits an eligible person from making a family provision claim. So that's the first thing. They might make a challenge because they feel that what you've left them is inadequate. So it doesn't necessarily stop them from making a claim. So that's something, to keep in mind as well. But again, come and speak to us, because as part of the strategy, we look at things, for example, like putting in place what's called a Section 100 statement. So because you're not going to be alive to give evidence as to the relationship that you've had with your son to date, it's almost a document, and it's like you were on the stand, that if there was a challenge, it can be tendered, into the mediation, or if it got to the litigation point. So unfortunately, you can't stop someone from making a claim if they're an eligible person. But again, it's all about that estate planning strategy and how we try and mitigate a successful claim, because just because someone can make a claim doesn't mean it will be successful.
And of course, the relevant time for the claim is on your death. So it really depends on the applicant's circumstances at that point of time, not necessarily at the time you're making your will. Hence the importance of reviewing your will regularly as everybody's circumstances change. But that's another point to note.
Yeah, and as Danielle said, which is important, the court will look at a various of factors when there is a claim. So they look at the factors of the claimant, so your son, and then also the other beneficiaries. You know, does someone have a disability that may require more of your assets? So it's very dependent on the specific circumstances of each case.
Right, thank you. And I've got a question from Bronwyn as well.
Hi, thanks so much. It's just a quick one. If you review, like if you do this all, like say I did it all about 5 years ago, might need a review. I understand that it would cost, you know, the same as what you just put up there initially to do a fresh set, but do you have to repay that similar amount every time you review?
So I'll take that one, Bronwyn. What we mean by review your will isn't necessarily that you need to redo your will. As Laurie and Danielle have both touched on, it's important to just keep in mind what is in your estate plan, who have you appointed in your powers of attorney, what have you got written in your will, and whether it's still current. I'd be happy to share around our estate planning checklist, which is a great prompt as to various factors that may have happened, which means that, okay, you really do need to review your estate plan because there have been circumstances that will impact your documents. Now, when it comes to, you know, we'd be happy to have a quick look over what you do have in place and let you know whether we think that there is a need for a change. If we need to redo your entire estate plan, then it might be that the package price applies. But it really depends on what's in your current will, what your current circumstances are. You know, if there's something small like a change of an executor, that might be done by a codicil and that will be charged differently. So we'd need to look at what you've got in place in your current circumstances to answer a question around price.
Yeah, no, that's great. Thanks. Thanks so much. Generally, that was incredibly clear. That's helpful.
Okay,
Pleasure.
well, thanks, Anita. I think well we're 6:34, and I think we'll wrap it up. So just want to, on behalf of Sterling Planners, thank you all the clients for coming along this evening. I'd like to thank Danielle, Laurie, and Anu for the presentation. It was wonderful. Just post this presentation probably early next week. We will be sending a copy of the presentation. We've recorded this, so you'll have a recording of this, and also we'll include a copy of the checklist to everybody as well. So we'll do that. And if you would like post this session to make contact with the team there, just either let myself or let your advisor know, and we can make the arrangements to do that. One of the things that we tend to do if you come through us is that we can provide, with your permission, the latest fact find. So you don't have to go through the whole fact find process again. And that's what we tend to do with all of the clients that go through the review process with equity trustees. Just saves a lot of time and effort to get the same information across. So please do that. But just like on behalf of everyone, say thank you very much and have a good evening. Thank you.
Thank you,
Good
everyone.
night.
Thank you.